Welcome, everybody. Thank you for joining us for this Art in the Libraries virtual program. We're excited to co-host with Morgantown Now. I'm Beth Torin, interdisciplinary librarian, with co-host Vicki Connor from the League of Women Voters, in for Sally Brown, exhibits coordinator for the WVU Libraries and lead curator of Undefeated, canvassing the politics around voter suppression since women's suffrage. As a reminder, the session is being recorded and will be documented on the library's website for public viewing. We welcome questions in the chat box and we'll address those at the end of the presentation. And we'll also post a survey link to get your feedback in this session. So I'm honored to turn this over to Nicole Wilson-Carr. Nicole Wilson-Carr is a nurse practitioner at WVU Medicine. She's a member of the Morgantown National Organization for Women and the Morgantown-Kingwood NAACP. Welcome, Nicole.
Thank you. So we're in for a treat. Professor Ellis's research explores how racial and class-based oppression interact and continue to abridge and deny the right to vote to communities on the margins of American democracy. His work has analyzed voter identification laws for their socioeconomic effects, situated felon disenfranchisement laws as enforcing a political underclass, analyzed the theoretical scope of the Citizens United decision, and described the ideological drivers of voter suppression. His work is interdisciplinary in nature, spanning doctoral legal analysis, critical political theory, race and the law, legal history, and innovative legal pedagogy. Professor Ellis's current research focuses on how ideologically driven conceptions of wrongful voters diminish the right to vote. He has also written on critical legal theory and legal history. I'll now yield the virtual platform to Professor Atiba Ellis.
Good evening, everyone. It is a pleasure to be broadcasting to you virtually. In the era of COVID and in realizing all of our safety comes first and foremost, my one regret today is that I can't be with you in person, at least now. Hopefully, when the time is right, we can share in person. Those of you who know me know that I started my academic career as a voting rights scholar at West Virginia University, and I still consider it near and dear to my heart. I even came close to Mountaineer colors today. So, but we're not going to talk about that. We're going to talk about the right to vote. And I am calling this talk, let's see, the voting rights paradox, the politics of exclusion as threat to the franchise. And I try to be internet savvy when it comes to all these things. So, of course, I've shared both my website and my Twitter account. So if after today you want to continue dialogue. Anyway, so the voting rights paradox, the politics of exclusion as threat to the franchise. Well, this title is kind of a strange title in part because in some ways, it's a paradox when we think about voting in terms of its modern incarnation, right? In our modern aspirations towards a democracy and towards universal suffrage, that all voters who are qualified to vote should be able to vote. But even in that sentence, in and of itself, the whole notion of who is qualified to vote has served to continue to define the franchise in the United States. Or to put it another way, we have always excluded people who we have deemed unworthy of the franchise. We have always, and we continue to, measure our notions of election integrity, at least in part, on measures of worthiness, on measures of who ought to be able to exercise the vote. Now, I capture this in this thesis that I'll just share, right? The scope of the franchise in the United States has always been tied to the politics of worthiness as a way of insulating suffrage from those deemed illegitimate, immoral, or too dangerous to the privileges of citizenship. This rationale has translated into the use of barriers deemed rational for measuring worthiness, socioeconomic and status measures that targeted vulnerabilities in citizens on the margins. This plays out clearly, but not exclusively, in the interrelationship between anti-Blackness, racial subordination, and the franchise. And this pattern of intersectional voter suppression continues despite the trend towards universal suffrage and the past and present anti-discrimination laws specific to voting. All right, so that's a lot of talk meant to speak to law professors to a certain extent, but let me break it down this way. We have always thought of voting as a measure of our values, and as it comes from that place, the measure of American values, it is all about who gets to be an American and who does not get to be an American, right? And we have throughout history deemed certain voters illegitimate or immoral or too dangerous. I call this the vicious voter thesis, or the vicious voter idea. In fact, I am on the front end of working on a book project that tries to capture this long history. But to be specific, and the thing that I want to talk about in depth is that on top of the various levels of identity that have been used as proxies for deeming people illegitimate or immoral, including gender and race and national origin, the heart of the matter is that the right to vote has always been measured against and always been calibrated by America's deep belief in anti-Blackness. Anti-Blackness. That from our founding, and not just as the United States, but as American colonies, part of the deep history of what scholars call settler colonialism has been the expression of slavery, the expression of Jim Crow, and now arguably the expression of election integrity and voter suppression as a way to shut out people who are unworthy, particularly African Americans, from the franchise. But this also translates into race in a broader sense. Certainly Latinx people in the vote, that is a complicated history in and of itself. And I realize that this entire lecture has been convened in part to celebrate the 19th Amendment, the removal of the formal barriers for women regarding the franchise. And even that has its intersection with race, as we'll get into shortly. But the heart of where I proceed from as a scholar, and a heart of the idea, is that all of these notions of identity are measured by a politics of worthiness. And that then creates motivation, which turns into reasons to create barriers regarding the franchise that fall on these lines. And it's fair to say, too, that part of this is about wealth and about poverty. And in a sense, that's where our story takes off from in terms of thinking about the Constitution, which we'll talk about in a bit, or I'll talk about immediately, but property requirements, and then those requirements turn into requirements that set policies that target the vulnerable in our American society. So we claim universalism. We claim to have a right to vote. We claim to be a democracy, and yet that claim gets diminished every time we look at the history and see that it is a struggle that has the danger of repeating itself in terms of measuring the franchise by the politics of worthiness. This is what I want to discuss with you in this time. Now, I want to leave space in the questions to talk about the sort of very modern debates around voting. I know that the voting phase of the election will conclude Tuesday, and I am sure that there are lots of questions ranging from what happens if we don't know who the winner is Tuesday night, all the way to could this all be decided by the courts? I'm happy to entertain all of your questions, but I want to talk about this history as a way of framing even that conversation. So if we take our starting point then as the right to vote, if we think about it from the point of view of the original Constitution and what happened before the Civil War, what we have is an incomplete right and a default privilege. And by that, I mean, this is a right that was directed towards and favored the few and was treated as a privilege, but it's wrong to call it a right because it was not universal. Indeed, when we come to the Constitution and when we come to thinking about the government that was declared independent in 1776 and then framed first by the Articles of Confederation and then the US Constitution that we know of starting in 1789, when it comes to thinking about the right to vote in that context, you would think it would be there. But the honest to goodness truth is that the original Constitution, nor the Constitution even today, does not contain an express right to vote. Let me say that again. There is no right to vote spelled out explicitly in the federal Constitution. Now, what is there are clauses in the Constitution that make reference to the right to vote. So, for example, Article 1, Section 4, Clause 1 of the Constitution, the Elections Clause, says that the time, place, and manner of elections for the House of Representatives shall be prescribed by the legislature of each state electing people to the House. But Congress may at any time make or alter such regulations as to the time, place, and manner of those elections. In other words, the first, and in fact only, federal election in America was elections for the House of Representatives. The states got to define who participated in those elections, and they were considered to have the power in that regard. The Electors Clause of Article 2 is a direct reference to the Electoral College, which we'll get to in just a little bit. And it too was based on state legislator power. Now, these things just make it clear that states get to define the right to vote and that the federal government can then come in and participate when it comes to federal elections. But when it comes to each state, 49 of the 50 states and the District of Columbia all have express right to vote provisions that spell out who gets the vote. So think about it. The right to vote is not located in the Constitution of the United States, but for our purposes, the Constitution of the state of West Virginia. Now let's talk about the electors' representation in slavery briefly. So the Electoral College, as we know, the only direct election is for the House of Representatives. Senators were chosen by the legislatures of each state until the 17th Amendment was passed. And the president was originally intended, and it continues to be, elected by the Electoral College. As we know, the electors get appointed by the legislature to choose the president and the vice president. And that was only modified by the 12th Amendment. So, given those details, we now have the tradition where the Electoral College voters follow the popular vote of each state, in most states, except for Maine and Nebraska. But in the original Constitution, it was designed to be appointed by the president. And not only that, the apportionment of the number of electors each state received was based on the census. As then and now, it is based on the census. But in 1789, the census counted the whole number of persons plus 3/5 of the number of persons bound in servitude, as the Constitution puts it, or to put it in plain speak, the number of persons in slavery. So in this sense, representation in the Electoral College was inflated for the South, where slaves were held, where they counted the whole number of white people and 3/5 of the people in slavery, Black people, in order to constitute their representation in Congress and in the Electoral College. And that was to, in essence, run up the numbers against the North with its decline in slavery, even though slavery did exist in 1789 and it did not fade out into the North until the mid-19th century. But the point being, slavery is at a cornerstone piece of the way the American democratic system works. I say to my own election law class that slavery and the Electoral College combined to form the original gerrymander. Not gerrymanders in terms of the shape of electoral districts, but the overinflated power of slaveholding states to be represented in our federal government. So in that sense, in this structural sense, this is a piece of structural racism that continues on to this day. Surely slavery was abolished in the 13th Amendment, except as to people who committed crimes. But of course, beyond, and we'll get to felon disenfranchisement in a little bit, but beyond that, we have this dilemma of, in essence, small populations being pitted against large populations in the modern Electoral College, urban versus rural, and this dynamic, which had its origins in slavery, and in some ways, for example, prison gerrymandering, continues to be replicated today. And so you see here how this all connects to notions of anti-Blackness, right? Slavery. But let's think about this on the level of the individual voter. The original franchise limitation, this whole idea that vulnerabilities for some, for the many, created a privilege for the few. This idea was expressed through the property requirement. In the 18th and 19th century, up until about 1850, in order to vote, one had to own a substantial amount of property, somewhere in, say, the neighborhood of $500 worth, which by modern standards is in probably the tens of thousands of dollars. Now, that property could be land, and depending on the state, that property could also be slaves. But one had to have property in order to participate in voting. And the rationale being the ability to manage property represented one's ability to manage one's affairs and to represent others who could not be franchised for the government of the society. Now, when it comes to this, though, we know that history shows us that the de jure racial voting restrictions did not exist at the beginning of the 19th century. They are a product of how the 19th century proceeded, and indeed a product of how slavery evolved further and further, and racism evolved over the 19th century. But these things evolved out of the politics of whiteness. Indeed, it is every time universal male suffrage was offered, it was framed as white male suffrage. And all too often in many states, white male suffrage, a condition of that was passing a rule against African-American voting. And indeed, those same rules excluded women and Native Americans from voting. So, and I mean, when I say voter intimidation, I mean outside of the law, threats offered to prevent people from voting. This is well documented in the 19th century. Indeed, Alexis de Tocqueville writes an essay about voter intimidation and why Africans were not voting in the free state of Pennsylvania in the 1830s, just to name one example. But you see this story of the property limitation playing the first role, but racially targeted segregation from voting evolving. The high point of this was Dred Scott v. Sanford. Dred Scott v. Sanford is referred to as sort of the case of constitutional evil. The Dred Scott, if you haven't heard of it, is the case where the Supreme Court in 1856 basically said that people of African descent, not just slaves, but free blacks as well, no blacks had rights that white men needed to respect. And this filtered into voting, obviously. But the goal of Judge Taney in upholding this decision was in essence to make permanent slavery. And as a result, he shaped the meaning of citizenship going forward. I said 1856, I meant 1857. But the meaning of citizenship was shaped from this point going forward. So to be in accord with federal law, one presumably had to exclude African Americans from the franchise, and certainly many states took that as a lead. But then the Civil War was fought, and it was won by the North, and Reconstruction took place thereafter. And as part of Reconstruction, the Reconstruction Amendments were passed as a way to remedy the constitutional rift created by the war, by the Dred Scott decision, and by the status of slavery in the United States. Certainly the 13th Amendment, as I alluded to earlier, abolished slavery except for punishment as a crime. And then the 14th Amendment established a definition of citizenship, so all persons born or naturalized in the United States are citizens, and it established equal protection of the laws. Section 2 of the 14th Amendment, a constitutional clause that is not often thought about, but if you're interested in the academic analysis of this, I urge you to read the work of Franita Tolson in this regard. Section 2 prohibited states from disenfranchising men from voting, except for if they had participated in rebellion or another crime. And then the 15th Amendment became an explicit guarantee to protect the right to vote on the basis of race. Notice, it did not define the right to vote, but it said that one could not discriminate when it comes to voting. Now, of course, this was used as a means of participation for African American men in the South. So the Black vote surged because these guarantees were made, and the Union was present to protect Black voters from voter intimidation, terrorism, and manipulation. And so this shifted the legislatures, particularly in the South. The first elected African American, representatives to Congress and mayors and state legislators were found during this time, all because of the Reconstruction Amendments, the enabling acts that were passed to ensure that these amendments were carried out, and the fact that the federal army was there to protect Black voters. Now, from this point forward, the legacies diverge in terms of the right to vote, which is my way of saying from the Civil War forward, there was a vision of universalism, but this vision did not include African Americans, even though it did reach women. Indeed, when Reconstruction ended in 1877, voter intimidation became a thing targeting African American voters, right? So all that outright violence that was forestalled became the norm. But in addition, policies such as the poll tax, gerrymandering in order to keep down Black votes, literacy tests, and lest we forget, felon disenfranchisement laws built around the existence of the Black codes all came into being in order to diminish voting rights for people of color. And here's a list, including those, as well as understanding tests, grandfather clauses, and as I've alluded to, voter intimidation and lynching. Few, if any, of these practices were struck down precisely because the way these practices were written into the law, these practices were written in neutral terms. So rather than a poll tax or a literacy test being specifically targeted at African Americans, those tests were just written as general commands that needed to be passed. And of course, practices like understanding tests were about whether a voter could understand a particular clause in the Constitution, and the determination of this was purely in the discretion of the registrar of voting. So without federal intervention, and because these laws were framed to be neutral, they served to disenfranchise African Americans for nearly a century after the 15th Amendment was passed in 1870. So it's 150 years of existence didn't really mean much for the first 95. Compare that to women's suffrage. So what is interesting about women's suffrage is that there was a conversation back in the period of Reconstruction about whose rights ought to be pursued first. And there were strong arguments about a universalist approach to the right to vote, and indeed talk of even amending the Constitution to that effect. But the decision was made strategically that the African American male voting should be pursued first, and then women's suffrage would be attained. But of course, after the Reconstruction Congress did its work, the struggle for women's suffrage stalled and was a crawl until 1920. And so we celebrate 100 years of women's suffrage now. But notice the divergence, right? Women's suffrage was ultimately accomplished in 1920, and its goal was taken. There is little to no litigation about whether women should have the right to vote. And in fairness, a number of states passed the right over the period of time from 1865 to 1920. But the states that continued to be intransigent, their laws were upheld until the amendment was passed. Indeed, there's a famous case called Minor v. Happersett, where the court again said, well, bans on women voting in Missouri are perfectly constitutional because they do not match up with any constitutional command about whose right to vote would be protected. The Constitution only spoke to race, and a ban on women voting did not implicate race. But once women's suffrage was attained, it was attained for all white women. Certainly the de facto ban on African American suffrage continued to have force. And so African American women had to struggle particularly, especially through organizations like the NAACP and through state and local organizations, in order to advocate for their right to vote. And this is particularly true in the South, but true also in the North. And so this struggle continued in fits and bounds until the modern day civil rights movement of, well, not the modern day, the 50s and the 60s. And it came to a point, Bloody Sunday, Selma, Alabama, 1965, where we remember that John Lewis led a protest along with Martin Luther King and others, and that resulted in the national attention that led to the passage of the Voting Rights Act. The Voting Rights Act became a monumental change in the way the right to vote was conceived of. In fact, the act basically acted as a patch to this problem of structural racism built into the way we vote today by creating a cause of action in Section 2 that ensured that voting was non-discriminatory on the basis of race, and Section 5 required that states with a history of voting discrimination and a disparity between the majority and minority voters had to be under the supervision of the United States Department of Justice. They couldn't pass voting rights laws unless and until they were approved and they were examined to make sure that they didn't make voters of color worse off. This served as a patch in regards to our democracy in the sense that there were now national standards by which voting had to be done. And Congress then passed other statutes like the National Voter Registration Act of 1993, the Help America Vote Act of 2002 in response to Bush v. Gore. All of these then created this sort of infrastructure which actually pushed us towards a more universal individual right to vote. And it gave causes of action to pursue gerrymandering problems, including racial gerrymandering. So let me just take a few minutes to talk about voter fraud, right? In 2000, we think about Bush v. Gore, but there was also the election of John Ashcroft versus Mel Callahan to the Senate seat in Missouri. Ashcroft lost to Callahan, and Ashcroft faced the unenviable position of Callahan being dead. But Ashcroft's supporters argued that there was voter fraud in Missouri that tainted the results. They, in essence, explained away Ashcroft's loss based on this notion of voter fraud. That then created a mission for the Ashcroft Department of Justice once he got appointed Attorney General. The Ashcroft Department of Justice searched for voter fraud in terms of in-person voter impersonation fraud and couldn't find any. And this is documented in a 2006 study that DOJ committed. But the voter fraud narrative became a seminal part of a new wave of election integrity measures, such as voter identification laws, rules against non-citizen voting, and documentary proof of citizenship requirements, and similar measures. The thing is, though, there was no evidence of this voter fraud. But the court in 2008, in a case called Crawford versus Marion County, basically said that concerns about voter fraud in and of themselves can serve as a justification for passing these rules. Of course, these rules then got passed in a context of where Section 5 of the Voting Rights Act was still effective and useful, and so those laws ended up getting moderated. But then came Shelby County versus Holder in 2013. which made ineffective the Section 5 of the Voting Rights Act, not by striking that section down in and of itself, but by striking the formula used to determine which states were to be covered. And those states at the time included Virginia, North and South Carolina, Florida, Georgia, Alabama, Mississippi, Louisiana, Texas, Arizona, California, Alaska, New York, Michigan, and South Dakota. Many of the ex-Confederate states, but not all, but all of those states share in common, significant minority populations who had continued to be suffering from voter suppression. And Congress documented it when they reauthorized the act in 2006. But the court said, well, the South has changed and African-American voting and office holders have increased, and therefore Congress needs to come up with a new formula. This formula is unconstitutional. This brought another spate of litigation after Shelby County, where states like North Carolina passed laws, and with varying results. Some states like Wisconsin and Texas, their laws were upheld, but North Carolina, their laws were struck down because they were, quote, targeting with almost surgical precision African-American voters in that state. But notice here this connection between voter fraud as proxy for stricter regulations and how those regulations tended to more heavily impact minority populations. And then comes the election of Donald Trump. If you could see my screen, you would see me rain down tweet after tweet after tweet of his claims of voter fraud to explain away his 2.8 million vote loss, to justify his election commission, whose job was apparently to data mine to prove the voter fraud claims, but that commission was ultimately disbanded. Chris Kobach, its co-chair, also was a proponent of proof of citizenship laws. Those laws were ultimately struck down by a court because there was no evidence to support their need. Or put it another way, illegal voting by undocumented aliens was non-existent. And so I come to the end of this, and in fact, let me stop here by saying that the narrative that I've tried to show is the recurring cycles of history, the notion of worthiness as measured by race, replicating itself either through explicit bans in terms of the early 19th century, by the de facto poll tax era of the Jim Crow 20th century, and arguably the hyper-regulation of the franchise through the concern about election integrity and voter fraud in the 21st. This cycle continues to repeat precisely because there is no national standard for the right to vote contained in our federal Constitution, which means each fight has to take place state by state or federal court by federal court, but the federal courts, as we see currently, seem to be retreating from protecting voting rights. Particularly in the era of COVID, where courts claim to be reticent in the name of not wishing to change rules and creating disruption, but the risk becomes voters not being able to vote due to, as Justice Ruth Bader Ginsburg put it, no fault of their own. So in this sense, this struggle around hyper-regulation of the vote continues, and it continues along the axes of race. So with that, I'm happy to take questions or answer any thoughts or concerns you all might have.
I actually have a question. Sorry. All right, do you have anything, Beth?
Just going to say thank you, everyone, and we'd love to hear your feedback and questions, what you learned and what questions you have, and you can enter them in the chat or unmute as you did. Take it, Nicole. Thank you.
Sorry. I have a question. I just wonder, in terms of the Voter Rights Act, why wasn't it made permanent? Why is it that every couple of years we are going back and forth? I mean, it should be a given right, but we're constantly doing this, and that's why that section was struck down. So if you could talk to us more about the history of why.
Sure. So to be clear, Section 2 of the Voting Rights Act creates a permanent cause of action that voters can bring if they've had their right to vote abridged or denied on the basis of race. So Section 2 is not going to go anywhere, even though I'll just say as an aside, that definition includes explicit voter discrimination. It also includes, what's often called disparate impact theory, right? A law would tend to affect minorities more than the majority racial group. So, and that in and of itself may well be under threat given the new Supreme Court majority. Section 5 was always framed as a temporary measure. The idea was that this was needed to ensure that the states who were offenders would get their house in order, right? This was the way it was packaged in 1965. The argument was, well, remember what I said in the very beginning, the Constitution itself contemplated that states would have sovereignty over their voting regulations. And so this was a major infringement on that sovereignty without a change in the Constitution, or so the opponents of this argued. In 1966, there was this case called Katzenbach, South Carolina versus Katzenbach, where the court basically said, well, hey, Congress justified taking these extraordinary steps, and we, the court, are not going to interfere with that, and Congress has the power under the 14th and the 15th Amendment to do this. So what happened is in like 1968, 1970, 1982, and 2006, Congress once again made findings of fact and legislative purpose in order to justify the continued need. In fact, the body of evidence in 2006 to justify this was, we're talking like 20-some thousand pages of evidence around new forms of voter suppression that emerged regarding race, which justified Congress's reauthorization of the act. And to be blunt, in the Shelby County opinion, Chief Justice Roberts basically ignored all that and based his ruling on, well, we've seen change and Congress hasn't taken that into account. And so we think this is unconstitutional because it offends the dignity of the states. Now, I've argued in some of my work that, well, that doesn't take into account the dignity of the persons who are suffering this discrimination. So that's why we are where we are. A new Congress could decide to create a new Section 5. A new Congress, in fact, and I have argued that maybe there should be a Section 5 nationwide so that you don't have this equal dignity problem. And I've argued that there may as well be a federal right to vote, written into the Constitution, which in and of itself could address these issues. Of course, the problem is it's difficult to amend the Constitution, and that in and of itself was by design. But the effect of that seemingly neutral rule is to forestall change and ultimately place this structure in almost perpetuity.
Professor Ellis, we've
Yes.
got a couple more questions in the chat.
Okay.
Tom Rod says, great discussion. Thank you, Professor Atiba. Dean?
Oh, hey, Tom. It's good to hear
I was going to say, see how he can call you that. Okay. Name 3 top areas, there are many I am sure, where you think we may have huge court cases after next week's election.
Well, that depends on if we're arguing about the election itself or if we're arguing about what the next big challenge is. And in fact, I've already named one, which is what is the viability of, disparate impact theory under Section 2 of the Voting Rights Act. I would see that court case being brought sooner rather than later. I think within the election itself, I think the court, or at least a substantial minority of the court, made a strong signal this past week. In the Pennsylvania ballot extension case, you'll recall that went to the court twice. There was a majority to allow Pennsylvania to extend its absentee ballot deadline by 3 days so that, if it was stamped by November 3rd, you get 3 days to receive it, in addition to what state law then currently said. This was the Pennsylvania Supreme Court ruling on Pennsylvania law. Usually the US Supreme Court stays out of it, but at least 3 justices have said, well, maybe we should reconsider that. Kavanaugh, Alito, and Thomas. With Barrett on the court, that might be 4. If they get Roberts or Gorsuch, then you have 5-4. And so you could end up with a new Bush v. Gore scenario happening. Now, of course, all this depends on whether the election is close or not. My nightmare scenario is that the election is close in a battleground state, and we go to this sort of level of litigation to deal with this sort of issue. I think the third thing is basic ballot errors and the argument over how those things get corrected. Right here in Wisconsin, there was a state court lawsuit filed because there was a typo on some ballots, and the typo didn't interfere with the casting of the ballots, but it interfered with the counting. And so there's arguments about the deadlines, right? I think these kinds of, is it a mistake sort of thing will probably crop up. Bonus one, I worry about voter intimidation at the polls. I mean, I am hoping that the record number of absentee ballots makes that moot. But given the rhetoric of the president, I can't say that it's not. So there's all that.
Thank you so much. And perhaps you recognize Melanie Page. Hi,
Yeah.
Atiba. We miss you. In the 1619 Project, they argue that the Constitution is specifically set up to continue to dehumanize Black people in order to justify slavery. If our primary document of law is racist, how do we move either beyond it or above it, or can or should we?
Well, I think that, I mean, this is a big question. So I was a speaker in a seminar earlier today regarding the work of Justice Ruth Bader Ginsburg. And one of the things that I learned from this seminar was that she, in her jurisprudence, was very open, and in her legal scholarship, was very open to international approaches and using international treaties and examples from other countries to improve American law. So one tack to this question is sort of looking at how other countries talk about, voting rights and what we would call equal protection and the like, in order to think through what it is that we could do differently. And this is among law professors, for example, I have a colleague who says she made it her business to sort of meet the court where it is. But I have colleagues who also say, well, the whole thing is a mess and it should just be thrown out. But of course, the system, as I have said time and again in this talk, the system is designed to not be changed easily. I think that personally, a right to vote amendment, abolishing the Electoral College, and going explicitly for a national popular vote, either directly or what's more likely is the interstate compact to achieve those things, those are two steps in the right direction. I think the challenge ultimately is creating the political will for such structural change and realizing that issues as sort of basic as the right to vote ought to be nonpartisan and open and fair to all. So, and I have a little hope. And I didn't talk about COVID, so if you'll allow me 30 seconds. So COVID, yes, there is an upside to COVID. The upside to COVID is that it's made the conversation about finding alternative voting structures to accommodate the pandemic normalized, right? In the same way that we talk about, how the racial justice movement has sort of been normalized to a certain extent through this time, voting differently, having longer periods of time to vote, having more means to vote by mail, to vote by a drop box and the like, all of that is normalized. To me, this is the beginning in terms of voting rights, right? We can find a basic way that we can all agree on how this makes it this little bit easier. And then we can agree to that and then sort of build that momentum. At least that's my hope. And frankly, I didn't want it all to be doom and gloom.
Okay, we've got a couple more. Do you think Roberts believes his own arguments? If he does, is that better or worse for our undoing racism under the current court? Thank you, Judith Stitzel. I'm sorry, that's who asked the question.
Does Roberts believe his own arguments? I guess that there is a level of, I don't think he would argue things that he didn't believe, but I do think that for me, the hope with Roberts is even if he does believe in sort of rigidity around the Voting Rights Act, he has offered so many opinions that have not been helpful regarding COVID and voting, for example. And, his opinion in Rucho regarding partisan gerrymandering was I think, a wholesale cop-out. But yes, I said it. I honestly do think that the federal government can and should adjudicate partisan gerrymandering cases. And to avoid that is, as Justice Kagan said in dissent, unheard of and seemingly, preposterous. That said, when issues of legitimacy of the court come to bear, I think that catches his attention, right? Voting qua voting may well be on his sort of target list, but a situation like my hypothetical of the worst case scenario in Pennsylvania would put the legitimacy of the court at direct threat. And I think part of that is, to me, says, if these claims can get shaped into, claims about legitimacy of the court, legitimacy of the government, the legitimacy of the democratic process, then maybe they can get more traction and more attention. Remember, Roberts is also the guy who, if he's given a plausible argument, he will go with it, notwithstanding partisan views. And I would say, Kavanaugh is just straight up partisan, and I'm betting Barrett is similar. So, all of which to say, Roberts may well be the new swing vote. And if he can pull Gorsuch, we'll see.
Thank you. I can tell you're much loved and missed at the College of Law. Rosalind Lister, we certainly do miss you at the College of Law. Do you ever envision a standard national voting process? Probably not, but it seems to make sense given the possible foreign intervention issues in standardizing basic things like voting equipment. I know I'm dreaming, but what are your thoughts?
I think we will get there someday. I think that when the federal government is more willing to invest in doing the things that the Election Assistance Commission says should be done, then we will get going in that direction. But I think getting there means kind of getting the partisanship out of voting, which is also pie in the sky. But I also think that it means differentiating between the treatment of foreign interference as a clear and present threat objectively versus the kind of partisan lens through which it's read, right? I mean, the Mueller report lays out a lot of that evidence, and certainly that evidence continues to come in. But in the current world we live in of hyperpartisanship, this gets boiled down to a meme of, the people who hate the president want to talk about Russian attacks, and everybody who hates the president is wrong. So goes the meme. I mean, we have to break out of that kind of reductionism in order to even have the conversation that you're talking about, Roz. And oh, by the way, I hope my desk is doing well.
It's doing wonderfully well. Thank you.
Good. It's good to see you.
Good to see you too, Atiba.
You see, you realize that, had I been there in person, there would have been a whole, after party, But we'll just have to save that for when I can get down there.
And it's getting a bit after 7. I'm gonna wrap up the formal program, and all you guys are welcome to hang out and have a little after session chat. I will leave the room open. Thank you so much, presenters. It was an honor to have you, and our co-hosts, thank you. And friends, please take a moment to help us improve by completing the brief assessment that I'm going to put in the chat. And I'll do that along with some other links. Lastly, I want to remind you about the Art in the Libraries email newsletter and virtual programs page that has recordings of all our past virtual programs, and we'll have this one. And also that we'll be on hiatus from virtual programming until the spring. So we'll see you next year. And like I said, we guys are welcome to hang out and as long as you like.
Well, thank you for having me, and hopefully we'll do this again in a year or two in person.